Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast, Firearms Transportation, New York City, and the Second Amendment Edition. I'm your host, Grace Gotchling. On April 27, 2020, the U.S. Supreme Court released opinion in New York State Rifle and Pistol Association Incorporated v. City of New York, a case involving a dispute over whether New York City rules limiting transportation of licensed firearms to ranges within New York City limits and certain state-designated hunting areas violate the Second Amendment, the Dormant Commerce Clause, and the constitutional right to travel. Under New York state law, possessing a firearm without a license is prohibited. New York City issues premises licenses that permit possession of a pistol or revolver at particular address, and under City Rule 523, such firearms may not be lawfully removed from that address except for transport directly to or from authorized shooting ranges within New York City limits, as well as certain state-designated hunting areas. The plaintiffs, who hold New York City premises licenses, wish to transport their firearms to shooting ranges, competitions, and/or their homes outside of New York City. They sued for injunctive relief in federal district court, alleging that Rule 5-23's restrictions violated the Second Amendment and were otherwise invalid under the Dormant Commerce Clause, the First Amendment right of expressive association, and the fundamental right to travel. The district court rejected all these claims and dismissed the case, and the U.S. Court of Appeals for the Second Circuit, applying intermediate scrutiny to the Second Amendment claims, affirmed. The Supreme Court, however, granted cert to address whether the city's ban on transporting a licensed, locked, and unloaded handgun to a home or shooting range outside city limits is consistent with the Second Amendment, the Commerce Clause, and the constitutional right to travel. The case was vacated and remanded with a 6-3 vote in a per curiam opinion on April 27, 2020. Justice Kavanaugh filed a concurring opinion, and Justice Alito filed a dissenting opinion, in which Justice Gorsuch joined in full, and Justice Thomas joined except for Part 4B. And now, to discuss the case, we have David Thompson from Cooper and Kirk, and Amy Swearer, legal fellow at the Meese Center for Legal and Judicial Studies.
Thank you so much to the Federalist Society and for all of you for joining as well today. So I think when the Supreme Court took on this case earlier in the year, there was certainly a lot of excitement from the Second Amendment community. It had been about 12 years since Heller and 10 years since McDonald. And in that decade since, the court took on one Second Amendment case in Caetano, but really not much happened. Many lower courts continued to uphold a lot of gun control regulations that I think many people thought were constitutionally suspect under Heller and McDonald. So a lot of a lot of Second Amendment advocates, I think, were very hopeful that this case would sort of set up the next logical progression and at least give some sort of framework for the Second Amendment outside the home and build on Heller and McDonald. But alas, it was not to be. So to put it succinctly, this case more or less ended up as a wash, not a loss, but a wash. And we are effectively right back where we started. So I think many people listening to this teleforum probably have a decent understanding of the facts in this case, but I think it's worth going over just briefly as a reminder. So this case was about a New York City ordinance for handgun owners with what is called a premises permit. So not a carry permit, but just a permit to own a handgun inside their own home. Under the ordinance, people with this premises permit could have the handgun in their home and basically nowhere else. They could transport it to one of 7 gun ranges inside the city limits or to a gunsmith, and that's about it. So they couldn't take it to a second home. They couldn't take it to closer or more convenient ranges outside the city, and they couldn't take it to competitions outside the city. So in 2013, several gun owners commenced this lawsuit saying this restriction violated the Second Amendment. And then through 7 years of litigation, the city adamantly defended this law as consistent with Heller and McDonald, essentially saying, yeah, well, residents can have a handgun inside their homes, and that's all the court said we had to do. It also justified this law with some pretty far-fetched public safety theories, essentially this idea of, well, if gun owners can travel to more places with their guns, there's more opportunity for them to get into violent confrontations along the way. It's harder for law enforcement to determine, if they're using traveling to the range or to another home as a pretext for engaging in criminal activity and those sorts of things. And so, again, through 7 years of litigation, both the district courts and the Second Circuit essentially bought the city's argument hook, line, and sinker. And I think many people thought that might be it because, again, the court hadn't taken on a Second Amendment case in 10 years at this point. And then, as we all know, the court granted certiorari in this case. And at that point, New York City, which had adamantly defended this law, said, shoot. It saw the writing on the wall and seems pretty clearly to have expected it was going to lose the case on the merits. This was probably, at this point, the most restrictive law in the nation. So what New York City appears to have wanted to do was to avoid a broad ruling about the scope of the Second Amendment outside the home that would have endangered its other gun control laws. And so despite having vigorously defended its law, it now changed that law. It not only changed the law, but the state itself passed a law that would have made it much more difficult for New York City, if not impossible for New York City, to rechange it back. So New York City essentially said, fine, you can now travel, if you have a premises permit, you can travel outside the city to a second home, to gun ranges outside the city, at least insofar as that travel is reasonably necessary to get there. So then there ended up being a lot of questions about what does that mean? And the case really, at that point, turned into an argument over whether the court had to dismiss the case as moot, about whether the meaning of this new ordinance was constitutional. What did this mean? A lot of sort of factual arguments that were coming up. And I think a lot of people suspected that if the court were going to dismiss it as moot, it would have done so prior to oral arguments, perhaps even then immediately take up a new Second Amendment case for this term. So I think last week's opinion came as a disappointing surprise to a lot of people who expected that if the court went through oral arguments, it was going to get to the merits. What we ended up with last week was a majority opinion. It was fairly short, where the assumption is that the case was dismissed, sent back, remanded as moot. Though the dissent points out, and I think correctly, the majority opinion doesn't explicitly say this is an issue of the case being remanded because of mootness. We're just sort of left to presume it based on some of the other arguments there. And it's a fairly short opinion. I think the more interesting nugget here comes from the Kavanaugh concurrence and the dissent. So in the Kavanaugh concurrence, you had Justice Kavanaugh joining with the Chief Justice and then the more liberal wing of the court, ultimately joining with them on the procedural issues of mootness. But he did write a concurrence that ended up being a bright spot, a bit of a silver lining, where he now has become the fourth justice to really express a desire for the court to take up these sorts of Second Amendment issues, and sooner rather than later. So he pointed out that he shares the dissent's concern that some of these lower courts in federal and state courts are not properly applying Heller and McDonald, and that the court really does need to address this issue soon. And he even points out, as I hope David will go over, that there are several Second Amendment cases with petitions now pending before the court that would make sort of good cases for the court to take up. So there was a three-justice dissent. So this was a dissent written by Alito and joined by Gorsuch and Thomas. Thomas joined in part, but in the vast majority of this opinion. So they would not have found that the case was moot. They would have found that the respondents, the city in this case, failed to meet this very heavy burden of showing that it was impossible for the court to grant, quote, any effectual relief, whatever, to the prevailing party. So in their view, the petitioners had asked for unrestricted access to the out-of-city ranges and second homes. And the amended law's restriction to this idea of reasonably necessary travel did not clearly grant that unrestricted access. And moreover, they note that the court has generally been very wary of attempts to manufacture mootness in order to avoid adverse decisions, which again, I think it was fairly clear here that that was New York City's goal, was to avoid a very adverse decision. And so they would have proceeded to the merits and, in short, would have found that the city's violation of the Second Amendment was, in their opinion, not a close question. So in their view, the city couldn't point to any evidence of laws in place during the founding era that restricted gun owners to practicing inside city limits. And they also, in a section not joined by Thomas, Alito and Gorsuch, sort of called out the city's public safety arguments and some of the absurdity and complete unsubstantiation of that evidence. So that's sort of where we were left with this opinion. Now, where does this leave us? I think in terms of a Second Amendment legal framework for lower courts, again, it leaves us right back where we started. So in some respects, it feels like a loss for gun owners and a win for New York City. But I think that's because this was the absolute best case scenario for New York City. I don't think anybody really expected that if the court got to the merits, that it was going to uphold the ordinance. And so at that point, if the court had gotten to the merits, I think the best New York City and frankly, the best other gun control happy states could have hoped for was a very narrow ruling that said, we won't say where the line is, just that this particular restriction crosses it. So it feels like a loss because we did not even get that much out of the court after 10 years of waiting. But I think when we look at the facts, in reality, this was a draw, even if it was a disappointing draw. Because in the end, New York City did walk back its restrictions. It did give lawful handgun owners significant concessions. And it did so, I think, out of a very obvious fear that if it didn't give these concessions, it risked a holding that could have potentially endangered a lot more of its gun laws. And we did get a fourth justice going on the record saying we need to address this issue. We need to take up a Second Amendment case. And as I'm going to turn it over to David here in a second to talk about, we do have a lot of potential Second Amendment cases in the pipeline that I think provide, in many respects, a much cleaner opportunity for the court to issue a broader, more meaningful ruling than I think we might have gotten in this case. So with that, I'll turn it over to David to talk about sort of where we go from here and what we might be able to expect from the court going forward.
Thank you, Amy, for that excellent summary. That's super helpful and a great springboard. I'm just going to add a couple of footnotes. Number one, on the mootness claim, I know that the Chief Justice has come under some very heavy criticism. I believe the Wall Street Journal had an editorial claiming that he may have been rolled by an amicus brief filed by Sheldon Whitehouse, suggesting that the court would be politicized if it reached the merits here. I think that criticism is very unfair. I believe the case was moot after New York City and, more importantly, New York State passed legislation precluding New York City from going back. And so I wasn't surprised by the result. And candidly, I'm not disappointed by the result either, because this was an unusually narrow and peculiar law. I don't know of any other analog. And I think there was a concern that we might get a decision like Heller that just says, look, this is such an outlier. We don't even really need to provide a framework for other laws. And so I think it's really going to come to bite New York City and New York State that they've done this and played these games, because as I'm going to talk about in a moment, there are a number of other cases which are absolutely cert-worthy. I believe one of them will be granted cert, and they're going to have much more positive impact for those who believe in the Second Amendment. Another thing to note about this decision was Justice Alito's dissent. In Part 4, he turns to the merits, and in 4A, he looks at the history and text and concludes there's nothing in history that would serve as a basis or justification for this type of law. And consequently, he said the law is invalid under Heller. and that's the end of the matter. And that's certainly the history and text framework that anyone who's faithfully applying Heller would engage in. He then, in Section 4B, went on to analyze the paper-thin justifications that New York City had offered to defend the law and just rips them apart piece by piece. And Justice Thomas did not join that part of the decision. And so, I know some people have thought, well, what's up with that? I mean, and I think Justice Thomas is sort of signaling, you don't look at anything other than text and history. That's what Heller said. That's the end of the matter. This law fails under that test. Game over. Is Justice Alito and Justice Gorsuch, are they taking a different view? I don't think so. I think they were, to use the words of General Patton, making the rubble bounce. And they were just showing that, look, even under New York's own reasoning, there is no justification and they would lose. So I don't think there's anything worrisome about the destruction and dismembering of New York City's arguments. So let's look to the future and to do so, take stock of where we are. As Amy indicated, it's really been 10 years and candidly 12 since we've had any meaningful feedback from the United States Supreme Court, and it's really high time that they take another case. We are seeing the lower courts engage in massive resistance. It's really hard to think of another area of constitutional law where the lower courts have as systematically engaged in this sort of defiance in the last 50 years. If you go beyond 50 years, you can think of precedents, but not in the last 50 years. This is truly extraordinary. And the method of defiance that we are seeing is a so-called two-step framework with interest balancing. And I would really commend to everyone listening that you go out and you read the outstanding short article that my two colleagues, Joelle Alisea and John Ohlendorf, put together on tiers of scrutiny. And in that piece, they prove that, number one, tiers of scrutiny are totally ahistoric. And number two, they have always been used as a method to empower judges to clip back on the rights that the founders meant for all of us to enjoy. And so they've really destroyed the idea that tiers of scrutiny should apply anywhere in the Constitution, but certainly should not be extended to the Second Amendment. The lower courts have had some truly ludicrous justifications for this. They've said on some occasions, they've said, well, we can't answer this question. We can't strike this down because we don't have any explicit guidance from the Supreme Court. But of course, Heller gave plenty of explicit guidance, and courts all the time look at questions of first impression, even if they didn't have explicit guidance. So we're seeing this massive resistance, and I believe it's high time for the Supreme Court to take a case, and they will take a case for a couple of reasons. Number one, there are cases before them that fit squarely within the traditional criteria for granting cert. And number two, I believe the Supreme Court does not want to reward the gamesmanship and bad behavior of the city and state of New York. So what are the cases that have been held? Because since this petition was granted, there are, in New York City, there are a number of other petitions that have been held and are pending before the court. And the leading ones, and the area where I believe it's most likely that we'll see a grant, is in carriage. The court in Heller dealt with the word keep, and they signaled what the word bear meant as well. But certainly they've dealt with keep. Now they need to address what bear means. This is a super important right. There are tens of millions of Americans today who cannot exercise that fundamental right because of laws in places like California, New York, New Jersey, Massachusetts, and Maryland. And there is also a clear split in authority. We've got the First, Second, Third, and Fourth Circuits saying that there can be de facto bans on the right to carry, and we've got the D.C. Circuit in an identical type of law in the Grace and Wren decision saying exactly the opposite and striking down D.C.'s laws. And D.C., as you all may know, did not file a cert petition. Obviously, they, like Illinois, in the aftermath of the Moore and Shepard cases years before, had decided they did not want to take this case to the Supreme Court. They knew that they were going to be in a lot of trouble if the Supreme Court did grant cert. And so they didn't seek cert. And immediately after they declined to grant cert, we filed in New York, New Jersey, and Maryland saying, number one, you need to rule against us, and please rule against us quickly because we're going to file a cert petition now that we have a split in authority. And so we did that, and there are cases, in several cases in New Jersey pending. One we filed was called Rogers. There's a case in Maryland pending called Malpaso. The New Jersey and Maryland cases are essentially identical, so I don't really have a view as to which one the Supreme Court would take. There's also a case called Gould, which I argued in the First Circuit, and that deals with the restrictions in Brookline and Boston. Boston is a little bit different than New Jersey and Maryland in the sense of if you're a lawyer or a doctor or a police officer, you're allowed to carry a firearm. So it's not quite as sweeping a ban, but for those who aren't lawyers and doctors and police officers, it is a ban. And so I think the court could take any one of those cases, and we will have a great chance of success. If we look at the text, as I've indicated, it's right there. Keep and bear is a fundamental right. If we look at the history, we see that self-defense is one of the critical purposes behind the Second Amendment. And obviously there's, as Judge Posner pointed out in the Shepard and Moore cases, there's at least as much need for self-defense outside the home as there is inside the home. If we look at historical practices, we can see the founding generation understood that they had a right to carry firearms. George Washington frequently carried his pistols. John Adams, in his speeches in court during the Boston Massacre trial proceedings, acknowledged that the citizenry had a right to bear arms. Thomas Jefferson said to his nephew, "Let your gun be your constant companion." And there were no bans on carriage at the time of the founding, and indeed there were laws that required, in many instances, individuals to carry firearms. Indeed, the only thing the other side can point to is a handful of outlier jurisdictions after the Civil War where racists were trying to disenfranchise and disarm the freedmen, and a couple of towns in the Wild West where corruption was running rampant. And so you put it all together, there's just an overwhelming case that we have tens of millions of Americans whose rights are being violated. We've got a clear split in authority, and we've got some very bad behavior from some of the same jurisdictions whose laws are at issue. And so I think you put that all together, you're probably looking at a grant of cert in a carriage case in the next couple of weeks. Now, there are a couple of other cases up there. One category deals with modern sports rifles, which the left has tried to smear and defame by calling them so-called assault weapons. These cases are Warman out of the First Circuit and the Wilson case out of Illinois. And these firearms are the most popular in America. And as you know, in Heller, they said that any firearm that's commonly possessed by law-abiding citizens for lawful purposes cannot be banned. And so if there's any meaning to that, then these modern sports rifles have to be upheld, the validity of them and the right to own them. And so this would be another type of case that the court could take if it wanted to incrementally build out its its jurisprudence. And so I think that's another area we could see. There are a couple of other types of cases, out-of-state handgun purchases. That's in a case called Mance. There's a question about non-residents getting a carry license. That's in a case called Culp. But I think those are kind of secondary in light of the other cases that are in front of the court. And so I would expect a carriage case or perhaps a modern sporting rifle case to be what's granted. So with that, I'll turn it back over, Micah, to you and Amy for any further comments and or questions from those listening.
David, thank you so much for that, Micah. If I can just cut back in real quick to just sort of dovetail
Absolutely.
off of David. I tend to be in agreement that I think, there are some tangential Second Amendment issues out there, including a case out of California dealing with some of their handgun registries and frankly, a law about microstamping that is impossible to follow. The technology for the microstamping law does not exist. But I think really that the next natural progression is almost certainly a carry law, dealing with the Second Amendment outside the home, and possibly that issue of modern sporting rifles. So I am in full agreement with David there that I think that is the next natural progression, that the court probably takes on a similar case to the New York pistol and rifle case, but just sort of a broader law in terms of carry instead of these premises permits.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.